Hi, I'm Rusten Hurd with Colombo and Hurd Immigration, and today we're going to talk about some of the best ways to speed up processing of your immigration case. Okay, so we're going to jump right into the 4 best ways to speed up processing of your immigration case today. And first, I should note that in certain circumstances, there's just no way to speed up processing times. For instance, if your visa number is not yet available under the priority date of the visa bulletin, well, in that case, it's not going to be possible to speed up your case. However, there are many other situations where we do find that there are actions that can be taken in order to make USCIS act in a more reasonable time frame. And of course, reasonable time frame with USCIS is a relative term. You look back 5 years ago and then move forward today, we're seeing that over the course of various different immigration applications, USCIS is taking over 2 times as long to process applications as they did just 5 years ago. On average, immigration applications were taking only 5 months to process back then, but now it's 10 months or even longer on many types of applications. I-526s for EB-5 petitions, for example, are taking 30 to 50 months on average, according to the USCIS Processing Times Guide. So for a variety of different applications, the time frame has expanded significantly. But there are things that you can do to try and speed them up. And the first thing, possibly the most important thing you can do, is to file it right the first time. And of course, that seems obvious, filing it right the first time. Of course, everyone wants to do that. But I would say that the number one thing I see coming into my office that makes cases take longer when I investigate them is that the individual who filed failed to enclose the proper documentation, failed to answer the information on the petition or application correctly, or failed to properly analyze the situation to ensure they were eligible for the benefit in the way in which they wanted to file. And so it is vitally important that you take your time going through the initial application process to make sure you're fully complying and get legal help if you're not certain of how to proceed with that. Now, under the memorandum that the Trump administration released well over a year ago now, they can deny an application without even sending a request for additional evidence if you fail to include prima facie evidence, that's required evidence as part of the application that's necessary. So it's really important, number one, to file it right the first time. It prevents an initial denial, and it also ensures it's going to process as quickly as it can be processed. So the second step that you can take if your case falls out of processing times is to submit an online inquiry or call the 1-800 number with immigration. Now, I'm going to leave the notes and the link for the online inquiry request with USCIS, as well as the 1-800 number below in the description. But keep in mind that you need to verify your case is outside of processing times. I left the link also in the description for the way to check your case's processing time with USCIS. If your case is outside of those processing times, which they claim to be the standard amount, then you can go ahead and submit that online inquiry, let USCIS know that your case is delayed, and request that they take action on it. Now, what I found certainly over the last year or two in submitting a number of online inquiries or making the call, essentially works the same way, is that sometimes USCIS is actually very responsive. I have had a number of cases where when it's been outside of processing times, we've sent in the request and USCIS has taken action and approved the case soon after the inquiry. Of course, I've had other cases where I've had to submit multiple online inquiries and they've done essentially nothing. So it is hit or miss, but I definitely would recommend it as a good course of action to take when your case is taking longer than USCIS thinks it should be. Another option, the third option, a way to speed up processing of cases, is to submit a request for an expedite. And this is an option that I've seen that a lot of people I come into contact with are not aware of. A lot of, when I'm in consultations, and clients say they didn't know that they could do that. There are limited circumstances where an expedite request can be filed, but there's no form required. There's no additional fee associated with an expedite request. Instead, you simply have to meet the criteria that USCIS sets down for why an expedite is needed. And so they're going to look for either an urgent humanitarian reason or severe financial loss to the company or to the applicant. There can also be compelling government interests or some other circumstances as well. Now, but generally, most of my expedites fall in the category of either severe financial loss if the application or petition is not processed, or there's some kind of significant humanitarian basis for the application. And this, again, can be for any application or petition filed before USCIS. Any can be expedited. So the fourth area, and probably the area that I've seen, I've personally used the most over the last 2 years, more than I have in the rest of my legal practice, has been the filing of a writ of mandamus. And what that is it's a federal action, an action taken in federal court, and you're essentially asking a federal judge to make USCIS do its job and adjudicate the application. Under the Administrative Procedures Act, USCIS has an obligation to act in a reasonable fashion to adjudicate applications. But unfortunately, what we've all seen recently over the last couple of years is that's just not happening. They're not acting in a reasonable time frame to adjudicate these applications, and they're sitting and languishing. So even if your case is not within standard processing times, I should say is within standard processing times, even if your case has yet to meet whatever requirement that USCIS is saying how long it takes, you can still file a writ of mandamus. My experience has been on most of these, the assistant U.S. attorney that reviews the case has looked into it and found that we're right, that the case is taking too long. And after talking to USCIS, we found that we're able to get a decision issued on the mandamus action, and USCIS will go ahead and adjudicate the case rather than trying to fight it out in federal court. So as long as your case has been taking some time, the writ of mandamus can be a really effective option. We've especially seen it in the context of delayed adjustment applications, especially with approved underlying petitions, I-130s or I-140s, and then also in the EB-5 context with long delayed I-526 petitions. So in either of these contexts, filing a writ of mandamus can be a potentially good option. Of course, you'll want to seek quality legal counsel to have a good understanding of whether that's right for your case. Okay, so we've gone through the 4 different ways that these days it seems are the best to make your case process with USCIS as quickly as possible. File it right the first time, submit a case inquiry if outside of processing times, file an expedite request if you're eligible, and then lastly, consider writ of mandamus. I hope these suggestions are helpful to you. Please, if you have any questions or concerns or thoughts about your case, feel free to list them in the comments, and I'll make sure to respond to as many as I can. Thanks.